Hey folks, most Americans are taught that the Constitution was written to protect their rights, especially something like due process, which is a basic idea that the government cannot just take your life, liberty, or property without fairness, without law, without you having some sort of recourse, somebody who can say, no, that's not okay. In fact, the Fourth Circuit Court of Appeals, in a recent opinion in Kilmar-Brego Garcia versus Christie Nunn, said that the semblance of due process is the foundation of our constitutional order. A hell of a statement. But that's not what the Constitution did. The document written in Philadelphia in 1787 said nothing about due process of law. No guarantee of fairness, no protection of individual rights, no Bill of Rights at all. And that wasn't an oversight, that was a choice. The vaunted sainted framers, Hamilton, Madison, Morris, Wilson, weren't interested in protecting you from power. They were interested in centralizing it. They were interested in consolidating it. They wanted a federal government that could enforce contracts, collect taxes, repay war debts, be respectable on the world stage, and crush domestic resistance, like Daniel Shays. No rebellion there. Of resistance against oppressive debt and taxation without representation. Sound familiar? But they turned it into a rebellion to increase the stakes. We need this Constitution, we need this power, we need this authority, we need it now, or the whole country's going to fall apart. And rights? The framers saw them as obstacles for what they wanted to achieve and how quickly they wanted to achieve it. So when old revolutionaries, when the old patriots who were leading the patriot resistance movement in the 1760s and 1770s, people like Mercy Otis Warren and Samuel Adams, when they demanded a Bill of Rights, including protections like due process, Madison and Hamilton said no. Hamilton even wrote in Federalist 84 that a Bill of Rights was, quote, not only unnecessary, but dangerous. They believed that government shouldn't have to spell out what it couldn't do to you. And yet, somehow, due process and these protections upon which we rely right now made it in. Not because the framers changed their minds, not because of any kind of legal brilliance from these geniuses, but because of resistance. State by state, vote by vote, debate by exhausting, relentless debate, indoors and out of doors. Massachusetts said, we'll ratify, but only if you promise amendments. Virginia said the same, but stronger. Ratification passed by only 10 votes. New York said it even more loudly, and even there it passed by only 3 votes. And North Carolina, it didn't ratify it at all. It refused to join the Union until the Bill of Rights was a done deal and in the Constitution. That's how we got the Fifth Amendment. That's how the phrase due process of law entered the Constitution at all. But even then, it wasn't a real safeguard, not for decades, not until after the Civil War, when the 14th Amendment and its language of due process forced states to apply it. And not until courts, after the Reconstruction-era justices gutted it in the slaughterhouse cases and Crookshank, and then the civil rights cases in Plessy, then it's not until the courts in the 20th century began to the process of extending it to the states. It wasn't until Gitlow versus New York in 1925 that the process began of rolling back the Reconstruction cases to incorporate, through the doctrine of incorporation, the Bill of Rights to apply against state governments via the 14th Amendment's Due Process Clause. Before Gitlow, since at least the slaughterhouse cases in Crookshank in the 1870s, the Bill of Rights was restricted to only applying to the federal government. But Gitlow held that freedom of speech in the press, protected by the First Amendment, those freedom of conscience amendments that are collected under the First Amendment, were fundamental liberties, and they were protected from even state infringement by due process. And then later in the mid-20th century, courts began applying substantive due process, applied a little bit more fatally earlier in cases like Dred Scott and others. But in the mid-20th century, courts began applying substantive due process to personal rights, privacy, marriage, bodily autonomy. Now that might sound like progress, but it's a fragile, reversible construct. It's not a foundation, and certainly not a consensus. And we may be on the wrong curve of that merry-go-round right now. So when a court today says that the semblance of due process is the foundation of our constitutional order, it may sound reassuring. It really does. But as a matter of history, no. It's a product of mostly 20th century jurisprudence, a patchwork of resistance, redefinition, and retreat. And now we're watching it go backward again. Due process wasn't the foundation. It was a concession, a victory over the founders, not a gift from them. And in a moment like this, when rights are being rewritten, restricted, and erased before our very eyes, we should be very clear on this. We didn't inherit justice. We fought for it. And if we want to keep it, then we still have to.